Okay.
Yep, it's recording.
It's recording?
Yeah.
Okay. All the taxpayers in the state of California are seeking to foreclose the State Department of Mental Health because based on that, all individuals itemized placed into the housing of the State Department of Mental Health under the certain statutory laws and schemes such as the 6600 law and the 2972 law. 2972 law has been discontinued in 1986, in which the MPO law was declared unconstitutional. Anybody that was housed into the State Department of Mental Health under the 2962 and 6600 law, such as the SBP law, okay, have to receive treatment as a condition of parole. And after they discharge their number, they become citizens under their discharge number. But all taxpayers who pay into the State Department of Mental Health has been fraudulently paying taxes, and the State Department of Mental Health in the state of California, Sacramento, has illegally used the tax money for housing inmates under the itemized bills. Each inmate housed into the Department of Mental Health is worth $350,000 a year for each individual itemized patient per year, and per housing, per health care, and also real estate, land, and any other type of expenses that is deemed necessary that is spent accordingly and is spent annually each year on each individual patient. Each individual patient has already served their time in custody. Each individual patient has also claimed that they have already served their time in prison for a certain amount of a period of time, such as 3, 4, 5 years, or whatever the time that the State Department has sentenced them to.
And can I interrupt?
Sure.
And the vast majority of the civil detainees in the State Department of Mental Health in California, namely coming from the CDCR, which used to be the CDC, are MDOs who typically haven't done a violent crime and, like he said, have served their time entirely and are being held illegally. So it's not just SVPs. That's what I wanted to say.
Exactly. And it's both commitments of 2972 MDOs, members of defendants, and also SVP sexual violence predators. These individuals have already served their time, and also they have been misdiagnosed under a certain DSM-4 mechanism. The mechanism of the DSM-4 also stipulates in the category saying that the individual suffers from a mental disorder. But because of the DSM-4 was declared unconstitutional according to the OAL, which is Office of Administration Law, stipulated that they will not certify that into law. But there they will have to reamend their constitutional status under the DSM-4. Anything else, Nikki?
And these institutions, which are underwritten as mental hospitals, are in fact prison hospitals, and they are acting as prisons, wherein the institutions are holding these men and women in custody up to indefinite terms of commitment, and they're relying on underground regulations and arbitrary injunctions according to their in-house rules, and with their money and taxes and penalties and payments and duties due, they're overriding state, federal, and constitutional law, and they're violating human rights. And as well, they're in violation of, for example, the United Nations. They're in violation of international law, and they're basically essentially torturing people in the name of medical science, and they're really not trying to help anyone.
And to further review an investigation as we look through under Title IX. Title IX was inoperable, and then it was declared unconstitutional in 1991 under the Assembly Bill AB 1288. The Title IX also restricts individuals from getting certain privileges, or getting the adequate treatment here in the state hospital. Title IX also restricts Title 22. Title 22 gives people the most privileges, evaluation, proper evaluation. It sends people integrates people back into the community, so where they can serve their time into the community, and then they can go out into the civil community after they've been rehabilitated into remission. For the review, Title 9 is going into the California now, and also is getting ready to go through California Supreme Court through a review for consideration, so it can be placed under an injunction. Because Title 9 has violated the federal and state constitutional laws, and it also violates the conflicting law. It conflicts with laws against the federal constitution, and contractor standards and nature is unconstitutional.
And Title 9 as an injunction is where the administrative agents of the California Department of Mental Health go into court, and basically they buy the ruling that serves them. That's an injunction. That's what we mean by when we say injunction.
Exactly. Injunction, for the injunction, the meaning as what we're looking at too, and for the consideration, we would say that conjunction means that where a court will order the State Department of Mental Health or any corporation to stop or do not do these certain type of corporation acts anymore, because the corporation fall upon a pro se violation. Per se violation means that any corporation that doesn't have a commercial reasoning, or if it doesn't fall upon a commercial law, or if it doesn't abide by statutory rights or any codes or regulations. Also, the injunction that we're putting on there, we put an injunction on for the corporation that's going to be coming next, that is going to be coming next later on in the next episode when we speak about corporate law and stock and bonds law in regarding the relation to what's the issues that is addressed here in this subject.
And currently the CDMH, which stands for the California Department of Mental Health, it has transposed Title IX into Title 11, where no mental patient in the state hospitals have any rights. They don't have any LPS rights, Lantern-Petra Short Act rights, and they don't have any other rights according to the policies of the hospitals. And so this Title 11 comes from the CDC, the California Department of Corrections, and the administrative agents of the hospitals claim that the mental ill ex-CDC prisoners are still prisoners, but they have diagnosed all of them with invalid mental illnesses which don't do anything about the alleged mental illnesses. And so this Title 11 ensures that they essentially don't have to provide any treatment. And you can refer to the affidavit of Robert Whitaker for some information about some of that. So through Title 11, these prisoners, detainees, are being held, and the institutions don't have to provide treatment for physical ailments, handicaps, disabilities such as access to wheelchairs, hearing aids, glasses, all of that stuff. It's minimized. There is a little bit of help here and there, but there are long waiting lists. And although the common mental patients in these institutions are prescribed and given so-called psychotropic medications, especially neuroleptics, are in fact coerced and forced to take the drugs. And even at that, there's minimal oversight for the treatment, and 9 times out of 10, the institutions rely on emergency drugging where the patients are slammed to the ground or beaten up and put in isolation cells and are given punishment doses of drugs. And so that's really what the institutions are relying on for their mental health protocols of treatment.
According to 1983, we had this sort of an investigation regarding an injunction on the state hospital. The state of California stipulated that they was immune from the damages, but they cannot be sued because they were protected under the 7th Amendment of the United States Constitution. But under the case law on the Hydra versus Hunter stipulates that a state official can be sued in their individual capacity. And the state also stipulated that because they've been immune from the damage, that where a person that tried to file a lawsuit against these people for devious discrimination and forced medication and any of these wrong corporate crimes, it says stipulated we don't have a claim against them, or any patients don't have a claim against them. And according to the Uniform Commercial Code, a person has a claim against the institution. And claim means that statement of claim also stipulates that there's a memorandum of points of authority saying that yes, you sue the person against this past. So 1983 actually has very state of claim stipulates that there's a memorandum of points. Even though they stipulate there's a memorandum of points, they give states a leeway to create bylaws that still in, as we talked about earlier, and it comes to the federal and state law. So now, since it comes to the federal and state law, they feel that now they have qualified entities to stipulate the ordinance for them based on unqualified entities. Any state employee who acts within the scope of their practice will be considered qualified immunity. But in further discussion under the context behind the investigation of the per se violation is that the commercial reasoning has conflict with actual constitutional law. Once it's conflicting with constitutional law, then therefore there's no commercial reasoning, and therefore the qualified immunity doesn't have a claim against itself, and therefore their immunity has been forfeited.
Yeah, and they don't have qualified immunity, and they are not sovereign against the state law or the federal law or Amendment 11, even if that, because they're not a prison. Technically, they're a corporation, and the Amendment 11 to the United States Constitution says, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So this applies to the state entities, and the state hospitals are corporations. They're not prisons.
And according to the Fifth Amendment, it stipulates that no person should not be punished or twice placed in jeopardy for life or limb. Under the 14th Amendment, it stipulates that all men in the United States have a right to due process and equal protection clause. Under the First Amendment, it also stipulates that a person has a right to freedom of speech, freedom of liberty, freedom to address the government, and freedom of any other thing that is necessary. Under the Second Amendment, it also stipulates that a person has a right to bear arms, which means they have a right to assembly and bring these grievances to the government, and to also draw arms with each other to protest for this matter.
Yeah.
You turn the recording off?
No, keep going.
Oh, okay. Oh, no, I'm done. Go ahead. It's your turn. Go ahead. I was addressing the Constitution Amendment.
Yeah.